The preacher, Gabriel Olivier, described by some reports as a street preacher, was preaching outside an amphitheater in Brandon, Mississippi. The city passed an ordinance limiting protests, demonstrations outside the amphitheater around event times, roughly 3 hours before an event and 1 hour after. During that period, it required protesters to remain within a designated protest zone. Olivier violated the ordinance by preaching outside the designated zone, was arrested, fined, and received a suspended sentence, no jail time, after pleading no contest. He then filed a civil rights lawsuit under 42 U.S.C. Section 1983, claiming the ordinance violated his First Amendment free speech and religious liberty rights. Why it matters. The central issue is procedural, not yet whether the speech restriction itself is constitutional. Namely, whether someone who pleaded no contest and was punished can still bring a civil lawsuit under Section 1983 to challenge the ordinance going forward. Lower courts dismissed the lawsuit based on prior conviction precedent, claiming that allowing the suit would undermine the conviction. If SCOTUS allows the case to proceed, it could open doors for many people to challenge local laws restricting public speech, even after a conviction or fine, as long as they seek injunctive or prospective relief, i.e., prevent future enforcement. Supporters argue that the lower court rule effectively prevents a perfect plaintiff from ever challenging ordinances that target speech. News developments. The Supreme Court recently agreed to hear the case, scheduling a hearing this term. Many civil liberties groups, from religious organizations to libertarian think tanks, have filed friend of the court briefs, highlighting broad support across ideological and faith lines. The court's decision won't only affect this preacher or this city, but potentially shape how local governments across the U.S. can regulate protests, religious speech, or other expressive activity in public spaces. Historical context. This case echoes earlier free speech and religious speech cases decided by SCOTUS. In Kunz v. New York, 1951, the court struck down a permit requirement for public religious speech as unconstitutionally broad. In Fowler v. Rhode Island, 1953, the court ruled that penalizing a religious minister for a peaceful public meeting while allowing other groups violated the First Amendment. And in Feiner v. New York, 1951, the court allowed speech to be restricted based on its potential to incite a breach of peace, a precedent that sometimes limits public preaching depending on context. That history shows a long tension in U.S. law between protecting free speech, religious expression, and allowing government regulation of public order.